Madam Deputy Speaker, and I rise to speak to the amendments that I have laid. And I'm delighted to be able to have another attempt at trying to stop this government from doing something that defies justice as well as common sense and will make our streets less safe. As I said in the committee stage of this bill, my amendments would mean that some serious offenders would not be given the get-out-of-jail-free card being proposed by this government. Now, since the committee stage of this bill, we've had the ludicrous situation involving Hadush Kabata, who was released from prison after being jailed for sex offences. Quite rightly, there was a public outcry and widespread condemnation from politicians. The massive irony of all of this, though, is that if this bill had already been passed, he would have qualified for the presumption of a suspended prison sentence and would not have been in prison in the first place. My amendments 15, 16I, 24, 25I would mean that foreign offenders and sex offenders would not be included in the presumption in favour of a suspended sentence when an immediate prison sentence had been deemed to be the right outcome by the courts. These amendments would mean that someone like Kabata would still be sent to prison in future. I hope those on the other side listening of the House now agree with these amendments, especially when the Health Secretary has said this man was behind bars because of serious sex offences. So the idea that he's loose on the streets is incredibly serious. Perhaps the Health Secretary will now back my amendment, and perhaps the Health Secretary will have a word with the Justice Secretary, who will also back my amendment. Regarding the Kabatu debacle, people have been blaming the incompetence of the prison staff in releasing him. And yet, if the government does not accept these amendments, then we will not need to be concerned about the incompetence or otherwise of our prison service, because these offenders won't even be going to prison at all. What we will, however, be sure of is of the incompetence of this government allowing these sentences changes to happen and not to be sending offenders like Kabatu to prison. Even the Secretary of State for Justice himself apparently said, let's be clear, Kabatu committed a nasty sexual assault involving a young child and a woman, and for these reasons this is of course very serious. He also said on Monday in this House, Mr. Kabatu's victims are rightly outraged about what has happened. I am livid on their behalf and on behalf of the public, and that Mr. Kabatu is back where he belongs, behind bars. If it is so serious, and he really means that Kabatu belongs behind bars, why, on his watch, will this bill ensure that the next Kabatu will not be behind bars and won't be sent to prison in the first place? These are serious questions that need answering, and it is not too late for the government to stop this dangerous aspects of this bill and prove to everyone outside this chamber that they're not hypocrites by accepting my amendments. And while they're at it, they need to seriously reconsider accepting my amendments 20 and 29, which would stop those committing knife crimes from being eligible for suspended sentences. When it comes to proposing a non-prison sentence for carrying a knife on our streets and even allowing it to apply to those committing these offences more than once, the government should hang its head in shame. I'm sure many members in this House will know of cases where someone has been injured or killed by a knife. Everyone who votes for this bill without amendment is going to be voting to let someone carrying a knife, threaten with a knife, and even repeatedly so, avoid prison today. When this inevitably leads to, I will indeed give way.
For giving way. And while I don't doubt for a second her impassioned belief in the need to keep dangerous offenders off our streets, would she agree with me that it was actually the Conservative government that cut funding to our prisons, a 24% real terms cut from 2010 to 2015, resulting in 30% cuts in staffing. And this does have clearly an impact on the ability of any government to send individuals to prison. And that was something that happened under the last government.
If I could just remind the member of those dates and what had happened. The government had collapsed the economy at that time. The coalition had been brought into power to absolutely get the books back on track. And unfortunately, as always happens after a Labour government, spending then does have to be cut because they've no doubt bankrupted the country. But from there, when there was more money in the bank, we do need to invest more. That is why the last Conservative government put £4 billion into building more prisons. 3 are now completed, and there is a further 3 left to be completed. So do members really want it on their conscience that they are now changing the laws for people with knives, threatening with lives? I think not. And Labour has always talked tough about this matter, but now, in a position to do something about it, fail. And words like those of the Honourable Member for Putney. Under a Labour government, there will be tough consequences for carrying a knife. A Labour government will end the empty words and apology letters for knife possession and will guarantee sanctions and serious interventions for young people who carry knives. Those were the words of the Labour Party. But sadly, Labour won't. Time and time again, Labour is proving to be a party of empty words and broken promises, and this will be yet another one. And there will be plenty of people ready and willing to remind them in the future of this, especially an outraged public. Yeah. And there will be no words of comfort for the family of a needless victim of this type of crime. Another thing members should think twice about is the fact that those who assault emergency workers will also be included in this prison avoidance bill. I know many Labour MPs who very much supported the introduction of the offence of assaulting an emergency worker with its increased sentence for those convicted. And yet, all of this will have been for nothing if this bill gets passed in its current form, because people assaulting emergency workers with sentences of 12 months or less will be very likely to avoid prison altogether. So having worked hard at the time to increase the sentence to 12 months in prison for assaulting emergency workers, they will now effectively be agreeing to 0 months in prison in many cases. The Honourable Member for Rhondda and Ogmore, who introduced the Assaults on Emergency Workers Offences Act 2018, did so, in his words, to ensure those assaulting emergency workers felt the full force of the law. The Right Honourable Member for Lewisham West and East Dulwich said that she was supporting it. The legislation was long overdue. The trade unions supported it. The GMB national officer said at the time, it's welcome to see arrests taking place, but we also need to see an increase in prosecution and tougher sentences handed down for these unacceptable assaults. My amendments 17 and 26 would exclude this offence from the bill and show support for those who risk their lives to keep us all safe. What a kick in the teeth it will be for emergency workers to know that this government does not have their backs at all. Yeah. It seems it would rather be on the side of many of those who assault our emergency workers or who keep them from being sent to prison, as they should be sent to prison for doing that sort of thing. These amendments would also exclude assaults on those generally providing a public service. My amendments 16 and 25 also provide a number of exemptions to the presumption of a suspended prison sentence based on the history of offending of the criminal in question. For example, where someone has committed a particular serious offence that would be covered by the unduly lenient sentence scheme, or one that required a mandatory minimum sentence. The unduly lenient sentence scheme covers sexual offences, stalking, putting someone in fear of violence, serious harm or distress, controlling or coercive behaviour in an intimate or family relationship, and inflicting grievous bodily harm or unlawful wounding, among other offences. The amendments would also prevent someone who is due to be sentenced for 3 or more offences at the same time being covered too. In addition, and crucially, these amendments would ensure that those who have been released early from prison and are out on licence would not be eligible for this presumption in favour of the suspended prison sentence for offending again when they should really be locked up. Getting one get-out-of-jail-free card due to early release is bad enough, but getting a second one would be an absolute scandal. And yet, this is precisely what is being proposed in this bill. My amendments 18, 19, 21, 22, 27, 28, 30 and 31 would remove the suspended sentence presumption for those guilty of firearms offences, burglary, terrorist-related offences and those who fail to surrender to custody. I cannot believe it has been necessary to have to even be putting these amendments down. Surely it makes sense that those people would be going to prison. But it seems, with this government, I'm having to lay those amendments to this abomination of a bill that is before the House today. As the bill stands, the presumption of a suspended prison sentence will apply to those where the starting point for their sentence was 18 months. Sentences of this length are not given lightly. You have to be doing something pretty serious for this to be the starting point. However, by pleading guilty and getting a third off, the offender may have to be kept out of prison as they then would be at the 12-month sentence point and be covered by this bill. Amendments 32 and 36 would mean that this would not be the case, as the sentence would have to be one of 12 months or less before the credit for a guilty plea was taken into account. Amendments 35 and 39 would mean that anyone avoiding prison, thanks to this bill, should have the maximum length of a suspended sentence given to them. In other words, the sentence would hang over them for as long as possible, a longer time as possible. Amendments 14 and 23 would also ensure that those given the suspended sentence are electronically tagged throughout, in the hope that this reduce them to be reoffending or make it much easier to catch them if they do commit further offences when again they should already have been in prison. The bill currently says that if the court is of the opinion that making the order would put a particular individual at significant risk of physical or psychological harm, then the presumption in favour of a suspended sentence would not apply. My amendments 33 and 37 would take this a stage further to include the public. Why not any individual as opposed to a particular individual? Amendments 34 and 38 would also take out the word significant, so that any risk would be covered. If the court believed that there is a risk to an identifiable person or unidentifiable member of the public, then they should be also protected them by ensuring that the person causing the potential risk to them is locked up. This does not seem like rocket science to me, and it would be completely wrong to do anything other than protect these people from all kinds of unnecessary risk. New Clause 43 would mean that the bill would cease to have effect 2 years after its introduction. If anyone is seriously supporting this bill today on the basis that it is a necessary measure to alleviate prison overcrowding, then they should be happy to agree to this, seeing as we are hearing how many prison places the government are going to provide, and we do know that there is another 3 prisons coming on board with about 4,500 prison places. More importantly, though, we do not need a crystal ball to realise that this bill is going to cause untold damage to the country. Offenders will be laughing all the way to their next crime, and there will sadly be countless needless victims of crime. The public may not yet be fully aware of what is coming their way, but in 2 years they will have seen some of the consequences of this bill, and many will want it to be urgently reversed. This amendment will make that happen. When describing the botched release of Hadesh Kabata early this week, the Secretary of State for Justice said, "Any release in error is one too many." Well, I say to him, any get-out-of-jail card under this bill is one too many. And this will certainly have been no error. It will have been, by those on the opposite benches, by those in government, very deliberate. My amendments would restrict some of the, or try and restrict some of the damage that will otherwise be caused as a result of this bill. It is absolutely clear that this government is proposing to let a whole load of serious criminals avoid prison and run amok in our communities. And I, as I'm sure any right-minded person here today voting wholeheartedly would agree, and they will be opposing this bill and agreeing to my amendments.